think we were told we've set a record for committee hearings today, so we're going to try to start this as we're beyond starting on time, but we're about to start. So if y'all would take your seats. So to get us started, I'm going to ask Representative Hill, who's at mic number 24,
Yes, sir.
to open us in prayer. Thank you.
Let us pray. Our dear, kind, and gracious Heavenly Fathers, we come to you with humble hearts, thanking you for the great privilege we have to serving in the great state of Georgia. We pray and ask for your wisdom and knowledge and understanding. We ask thy blessing upon our great state and our great country. And we pray, Father, that you'd lead and guide us, that we'd make the decisions that would be pleasing to thee. We ask this in Jesus' name. Amen.
Thank you, Representative. First on the agenda is going to be Senator Brian Strickland with Senate Bill 377. As he comes to the podium and or the chair. Either one, yeah, let's do the chair. Welcome back to the committee that he once chaired. So now you're on the begging. Now you're on the begging side.
I know the tables have turned, haven't they? Literally. Happy to be back. I bring to y'all Senate Bill 377. I think that this will be an easy one for us. All we're doing is moving the governor's office of workforce development from the Department of Economic Development to the Technical College System of Georgia. So right now, of course, this sits in workforce development. In the governor's 2019 budget, which you guys, I guess, soon are going to be passing, hopefully. This has already been contemplated. This move's already been put in that budget. And workforce development itself leverages federal funds from the Workforce Innovation and Opportunity Act, a federal law, to provide basic funds for adult education and post-secondary technical education. And bottom line, if I could sum up this bill, just say this: we're connecting with this bill those that are actually recruiting folks. Like I just left a press conference with Facebook coming out to Newton County. We're very excited about that. We're now going to connect those that are actually working with these companies that are coming to Georgia with the technical college system to actually train these employees for these jobs. So I think it's a common sense move. It's something that comes from the governor's office, and again, it's part of his 2019 budget. And with that, I'll be happy to answer any questions.
Well, you've got a couple, Mr. Kirby.
Thank you, Mr. Chairman. Just want to correct you. That's the 4-county industrial park, not just Newton. Walton County's in there as well. So.
That's true. That's true. I was a little more biased because my district line ends at the county
I know
line
that.
there, but, yes,
But Walton's
we're
a
happy to have
big part.
Walton, Monroe, not Monroe.
Morgan.
Help me out. Morgan. There's one more. What's the fourth?
Oconee.
Oconee. And Newton County, all included. All excited about getting Facebook.
Well, I'm just glad they decided to show up in person instead of trying to do a Facebook Live event. We have Mr. Parks.
Thank you, Mr. Chairman. Thank you, Mr. Strickland. Senator Strickland. I just had two questions. First, on lines 41 to 43, where the Technical College System of Georgia is now required to administer all these programs, do they have no problem in terms of administrative capacity to implement?
Yeah, they actually are in support of the bill. I'm not sure. Actually, Neil, who is with the Technical College System of Georgia, is not here. He had to go somewhere else, and I promised him I would get this bill out without him being here. But they are also in support of this bill. This bill comes from the Technical College System of Georgia as well. And so I don't know exactly what that's referring to, but they've contemplated this already.
Yeah, and in terms of putting everything together, it makes sense from an efficiency standpoint.
That's right.
Mr. Chairman, if I may ask one more question.
Mm-hmm.
At the end of the bill, from lines 63 to 67, it strikes out some language, and I was just wondering if you could discuss the effect that would have in regards to whether or not that creates additional flexibility as to how federal funds are used, or what was the purpose of striking out that language?
I do not know. I know that they are actually, that's referring to that Workforce Investment Act, and so they're still using those funds. I'm assuming we put that language elsewhere in the code. I'm looking for that.
I think starting at line 34. Yeah, it sounds like what they've done is they've taken the language from 63 through 67
That's right.
and segmented it out to 3 different areas to spell it out more succinctly.
That's correct. And you see, and starting on line 19, the new board, we're actually codifying this board as well, and the board shall meet all the federal requirements as well. And so this board's main function is to bring down those, of course, those federal funds. And so that's why we have that language in there.
Thanks,
That's a good
Senator.
question, though. You caught me on that one.
Sorry.
Well, I can tell you he's one of the more studious members of this
I
committee.
see that.
We're
And
glad to have him.
Nobody in the Senate ever asked that question, so that still says something about the House, I guess.
All right, I do not see any more questions. Is there anyone here to speak to the bill? Seeing none, what is the will of the committee? We have a motion to pass and a second. All those in favor say aye. Aye. All those opposed say no. You're now on to the infamous Rules Committee, and with that, I've asked Chairman Kirby to take over. I've got a committee in public safety that I've asked to be at, so
And
Mr.
Trey
Kirby.
Rhodes will be carrying the bill in the House.
Okay, thank you for that.
Thank you. Appreciate y'all. Thank you for your time.
Hearing only? Either order? Any order?
All right.
All right. Next up, we've got a hearing only on House Bill 184. Yes. And I understand Representative Cannon is going to present the bill, so.
All right, well, good afternoon, committee members. Thank you for hearing House Bill 184. I hope that you have a version of it in your packets there. The LC number is 363158ER. And want to bring to your attention, the bill has been restructured. I am now the sponsor, Kimberly Alexander being the co-signer, and there are other members who were on it before or new members who have joined. This bill is really about the fact that pregnant workers in Georgia are unable to ask for reasonable accommodations once they tell their employer that they're pregnant or are found to be pregnant. And there are a few things standing in the way that I think Georgia is equally posed to be able to address, since we are the #1 state to do business. I think we should be the #1 state for workers as well. So I'll talk about this from a few different angles. The first thing that I'll start to say is about who our workforce in Georgia is. So our workforce in Georgia overwhelmingly is actually women. So there are at least 42% of working mothers as the family's primary breadwinner in Georgia. At least 71% of mothers are in the labor workforce. And some show that at least 57% of the women who are working are possibly going to become pregnant. So when we think about what reasonable accommodations would be for these women, we might start at a place of thinking about what they actually get paid in some of these jobs. We, of course, know here in the state our minimum wage is $5.15, but it gets bumped up to $7.25 thanks to the federal minimum wage. But women still only make 70 cents to the dollar of what a man makes in Georgia. So even though we have a lot of women in the workforce, there are some inconsistencies with how they're able to actually provide for their families. So with the mismatch between job duties and demands of pregnancy, make it particularly hard on low-income women who are likely to work in jobs that offer limited flexibility. So if you think about those people that might be working in restaurants, low-income jobs, jobs where actually they do not have to provide the federal or the state minimum wage because they're exempted because of the type of work that it is. So people making $2.50 an hour as a waitress are some of these people that you could think of. Additionally, though, it affects women in high-paying jobs. So those jobs are generally the ones that are physically demanding. These are jobs where traditionally they've been held by men. They're in trucking or policing, jobs that are kind of difficult for women to enter. And so we think about cases like the case with a woman who was working at UPS. UPS, as you know, is based here in our great state. And she became pregnant and was looking for reasonable accommodations to her high-paying job. She was working an overnight shift and lifting at times up to 70 pounds a box. But because of her pregnancy, provided a doctor's note that said, I can only lift 20 pounds of this. A reasonable accommodation would be that I would only have to lift 20 pounds. And she was actually given unpaid leave and took her case all the way to the Supreme Court. And the Supreme Court actually filed in her award. She won the case. Ultimately, it is the case of, just to get you the name in case you want to look at it, Young versus UPS. So now that we've kind of thought about the types of women that we're talking about here, I think we should talk about the types of employers that we're talking about too. Of course, there are a lot of employers in the state of Georgia in different categories. Some of those have employment of over 15 persons. Some are under 15. I serve on the Small Business Development Committee, and just last year, some of you may know, we created a definition of small business in Georgia finally. We modeled it after Texas and some other states, ultimately saying a small business is under 100 employees and is based on their net revenue as well. So this measure, House Bill 184, in its version from last year, really applies to small and large business owners. I do not feel as though this measure has to move forward in including all of those employers, but these are the employers that technically we're talking about in this bill. So now that we know a little bit about who we're talking about, let me tell you a little bit about why I think this puts us in line with some of the changes that Georgia has already been working on and some of the things that we can possibly do with this bill. So being that we're one out of 18 states that have not closed our coverage gap for medical care for employees, so say that they're still not able to access the medical needs that they have, maybe they'll, rely on their, they will hope that their employer, what is the word that I'm looking for? They'll hope that their employer will help them with these issues. But the average cost of childcare, if they're choosing between having to pay the amount for their health care because they're in that coverage gap or pay for the child care, has gone up over the past 30 years in Georgia. As you may know, we've risen about 80% in how much child care costs in Georgia, and to that effect, I think that some of the people from other organizations have statistics on how expensive child care is. So if you're thinking not only, are people thinking about paying either for the prenatal care for their pregnancies when they're in that coverage gap, or they're going to pay for their child care, and possibly at the same time, they are not even being able to have reasonable accommodations at their job. Perhaps they're being put on unpaid leave, which is exactly what happened in that Supreme Court case, then we've really got an issue here. The pregnant woman, once again, is kind of in the middle of all of this mess. So in thinking about an effort that could make Georgia's pregnancy laws more adequate, I do think that this bill classifies some of the unfair employment practices that we could take away. So one of those, of course, would be not making those reasonable accommodations that I've been talking about. This is things like extra water, being able to carry water with them, being able to take seating breaks if they needed to sit down, and things as such. But there's also some measures in here about when the employer takes adverse action against an employee who recommends or asks for that accommodation. So as I've said, in the state of Georgia right now, even asking for that reasonable accommodation could ultimately out you as being pregnant and then allow for you to lose your job. Now, you're probably wondering, with us talking about the actions that employees can take against their employers if something like this happens, I am still very, very flexible with what this language will look like. And so I would like to continue moving into the bill, but just let y'all know that that is in there. So in thinking about what types of actions, though, that pregnant workers can file right now, we're not at a place of nowhere. There is somewhere that pregnant workers can go. They can file under the Pregnant Discrimination Act of the Civil Rights Act from 1964, which was ultimately created as a PDA in 1978, to say that I am pregnant, but I should not be considered to be a different worker. I should be able to continue to do my job. So as you see here, if a pregnant worker is filing that they've been discriminated against because they're pregnant through an EEOC complaint, they're in a conundrum again, because the PDA is going to say to them, we kind of can't give you reasonable accommodations because we, under the federal guidelines, are considering you to just be a worker like anyone else. But we know that pregnancy is technically a disability. So when we start to look at the Persons with Disabilities Act and what types of reasonable accommodations are given to workers who are disabled, we can start to look at the type of accommodations that are necessary for a worker who is pregnant. So in thinking about, illuminating that into what types of employers are already participating in this in Georgia are doing. Think about a Waffle House or a Walmart. These are places that intentionally save specific positions for folks with disabilities, people on the autism spectrum, and they make sure to have positions for them. And they give those reasonable accommodations to those workers. So we're able to see, okay, maybe there is something that Georgia is already doing in line with this. But unfortunately, Georgia went backwards last year in this issue. So last year, there was a case from an Atlanta worker named Miss Whitney Tomlinson. She was a single mother working at Walmart. She was ultimately a packer in the Walmart distribution center when she became pregnant. And at the point when her pregnancy progressed, she sought medical attention and asked the doctor to recommend what she could continue to do. That doctor recommended that she avoid heavy lifting and wrote her a note to give to Walmart. After she brought them the note here in Atlanta, Georgia, she was pressured then to take unpaid leave, just as what happened with UPS just a few years ago with the Supreme Court case. And that leave of absence then meant that she was going to experience more of a financial hardship in an already hard time, as I've kind of illuminated before. So she is currently filing with the EEOC to try to get some federal remedy. But in the meantime, she is left with no job and no accommodations. So although I do thank us for moving on this issue at the federal level in 1978, there really hasn't been much guidance on it since then. So I looked to see if there had been any recent guidance on the Pregnancy Discrimination Act. So in 2015, the only guidance that was given was after that Supreme Court case. And ultimately what they said was these are some of the following topics that other states could think about including in reasonable accommodations. So that would be applications of the PDA to lactation and breastfeeding upon returning to their job, the prohibition of forced leave policies, which ultimately we've seen in these two cases, asking that employer to take unpaid leave, and then access to health insurance. So these are some of the issues that I think on the other side of the pregnancy, Georgia can also work on. But I hope that we'll start by thinking about when the person is actually pregnant and how much of an issue or conundrum they're in just to be able to stay in their jobs. So as I close out, because I have taken up some of your time and I really thank you for listening, I wanted to provide this information to you so you have more information on it. Is ultimately that there are plenty of other states that have worked on this issue too. So at least 20 other states, as of July of this last year, are working on this issue. Some of them look just like us, as far as us having about 5 million folks in the workforce and them having 5 million people in their state. There are a number of other cases that I think could be interesting that we look on this issue on. And if there's any other information that I can provide to the committee, I'm really happy to do that because this is an important issue for our workforce. I do think that the Department of Labor is uniquely tasked with this opportunity to do so. So I have reached out to the Department of Labor to see what their kind of working process is on this issue. But as of right now, it seems as though they do not have specific I guess you would say signage or placards that go in Georgia workplaces that say, if you're pregnant, these are the accommodations you can ask for. But they have that for many other types of employment. So, you know, in the break room of other employers from the DOL, it'll say, you're an employer, the minimum wage is this. These are the things that you're entitled to. These are the types of actions that you can take. So the bottom part of the bill does speak to what the DOL could do to move this issue forward. And I thank you for listening to me speak about House Bill 184.
All right, looks like we have a few questions. Representative Bonner.
Thank you, Mr. Chairman. Thank you, Representative Cannon, for coming to the committee today. Just a few questions. How many times can an employee come back and ask for this for accommodations?
How many times can
For instance, is it open-ended? I mean, can they literally? We've got 4 children, so conceivably, you know, someone who was going to have multiple children could
Yes.
have these accommodations for years.
Yes.
So what provisions are there for an employer that hires someone who ends up having a number of children over the course of time?
Yep. So, you know, I think that the point that you bring up here about whether or not, you know, we treat each pregnancy as a new opportunity to ask for reasonable accommodations is interesting because, yes, upon each pregnancy, then that worker would be able to ask for reasonable accommodations because all pregnancies are not the same. If you've had 4 kids, then I'm sure that there have been some differences, you know, depending on how old you are. The doctor might have different reasonable accommodations they would want you to have, from you being able to do everything on your first child to maybe on that 4th child, you being, you know, on bed rest. But I do think that the bill speaks to that issue on lines 70 and 71. Which is page 3. It says the employer shall, in good faith, engage in a timely and interactive process with the job applicant or employee to determine effective, reasonable accommodations. So this is not something that would just stand in your worker file and say, whenever this person becomes pregnant, then they get these specific things. That employer would then be able to engage in that conversation and decide on what is reasonable at that time.
But it is conceivable that if someone were planning on having multiple children, they could literally have back-to-back accommodations so that they essentially they would be missing a tremendous amount of work, for instance.
So the whole point is to keep Georgia working. So it's to keep people doing jobs, not to be on unpaid leave. So the person would still be working and doing their job as asked for by their employer. I'm not quite sure I understand how they could not be working.
Well, but they would be doing their job, but with accommodation. So in the case of how much they could lift, how much time they could work, things like that, they would not. they would not necessarily be doing fully the job that they were hired to do.
That might be what you are putting forth here. I would definitely not say that. I think that the reasonable accommodations that the employer would come to would make it so that the employer would still have the jobs that they needed done. I don't see how every season would be exactly the same. Even if we're in the case of the UPS, things change, and
Well,
so
understand. I would say that, of course, and I appreciate you bringing up the issue of the small businesses, because, certainly for the larger companies like the UPS, the FedEx, Delta, those, it is a lot easier for those to make certain accommodations given the large workforce they have. It's a lot more difficult for the smaller businesses, and I'll say that I own a small business and we have a lot fewer than 100 employees, so we definitely fit into that category. So these are certainly considerations that we've got to look at across the board. Just the last question I wanted to ask, just to clarify, you had mentioned that pregnancy is actually a disability under the law. Is that currently how the law reads, that once you are pregnant you become disabled?
So it's pregnancy is also under for federal law. Pregnancy is considered under a medical disability, and depending on the range of medical implications of the pregnancy, yes, you could be rendered totally disabled, which is why you would be then put on bed rest.
No more questions, Mr. Chairman.
All right, Representative Park.
Thank you, Mr. Chairman. So just a few questions and comments as well. Representative Bonner, to your last point real quickly on lines 36 to 39, the definition of reasonable accommodation would not require an employer, especially a small business owner, to hire an additional person. So I think that may hopefully address some of the concerns that you had. But if not, we could obviously, of course, talk about it afterwards. Representative Cannon, thank you for bringing the bill. I did have a question regarding lines 96 to 106, which would create an additional civil cause of action for pregnancy discrimination at the state level. And I want to ask you a few questions regarding that. So is there a federal cause of action? And if there are federal protections, why would state level protections then be needed?
Okay. So yes, there are already federal protections. As I spoke to, the Civil Rights Act of 1964 was amended in 1978, which created the Pregnancy Discrimination Act. And that explicitly protects pregnant workers. And it makes clear that that employers cannot deny women or people who are pregnant just because they're pregnant. But the issue for me is that pregnancy discrimination is still very widespread, especially in Georgia. So when we think about I think they said there are about 31,000 charges of discrimination filed with through EEOC as of in 5 years. So between 2010 and 2015, there were 31,000 cases of pregnancy discrimination filed through EEOC. And that number hasn't really gone down since 2015. People are still having to go through this rigorous process. And as you can see, based on the 2 cases I brought here, I tried to bring 2 out of the 31,000 that really hit home to Georgia. It took them their whole pregnancy to even get a response on this issue. So I do think state claim or state action is necessary on this issue, not just put us in line with some of the other 20 states that are working on this issue, but because this discrimination is still in a conundrum and is still widespread.
So just to follow up on that, does federal law require reasonable accommodations to be made to pregnant workers?
No, federal law would require that the It does not require accommodations. It requires ultimately that they don't be discriminated against. So you can say an employer can't discriminate against you, and you bring up a claim that says, I think they discriminated against me because they didn't provide me reasonable accommodations. And the court can end up saying, yeah, they discriminated against you, and yeah, they still don't have to provide you with reasonable accommodations because it is not in the PDA.
So then, do you think that requiring, as you had earlier pointed out on lines 70 and 71, to require an employer to, in good faith,
Yes.
negotiate with an applicant or an employee reasonable accommodations, do you think that that could help reduce some of these cases that are filed against employers?
Yes, and I want the cases reduced that are happening in Georgia and people are having to take federal claim on. I do think that the employers in Georgia work under good faith principles, and they will be able to think about what their own reasonable accommodations are.
Thank you, Representative Cannon. Last point I wanted to make, especially in regards to equivocating pregnancy with disabilities. I know this committee recently passed unanimously House Bill 831, which was Georgia's Employment First Act that that strongly recommended or that created a council that would focus on competitive integrated employment as the first preferred option for working age individuals with disabilities. And I applaud you for bringing this bill that also encourages our pregnant workers to continue to work, and I hope that this committee will continue to consider discussing this issue.
Thank you. Me too.
All right, point of clarification for you, lines 36 through 38, 39, this wording is going to be very similar to the case that originated with the, I believe it was U.S. Air. Don't hold me to that, though. But under a reasonable accommodation, they don't have to create a job or even circumvent their typical bidding process or any CBA that might be in place. So when it talks about they don't have to hire somebody, if they don't have to take that person and move them to a new job. And that's kind of what this is saying here, where they don't have to create that new work either. Representative Cannon, I'd probably disagree with you. I believe the ADA requires a reasonable accommodation for a medical condition of pregnancy when one is available and appropriate for the workplace, not that it's not available just because the Pregnancy Discrimination Act doesn't cover that. It is covered under the ADA, as you said, as a medical condition.
I'm not sure that, I mean, I respect your reading of the Americans with Disabilities Act. From my reading, when a person is considered to be pregnant, it is still up to that medical provider to say what the medical implications are of their pregnancy is. So even if a provider says this is a normal pregnancy, there are no issues here, or if they say this is a pregnancy where there's a little bit of risk in it, they're not then going to have something from that medical provider that labels them as disabled. But technically, yes, they are disabled. So I think that if you're looking for an opportunity for Georgia to work on making sure that pregnant workers are somehow in line with disabled workers, we do need to have state remedy because the federal remedy does not speak to it.
Again, I disagree, but we'll move on. We got a question. Who's 24? Representative Hill.
Thank you, Representative. And we all, I think, would agree we do want to protect our children and our mothers as well. But my question is, I guess, just kind of a simple one. You said there's 31,000 cases of discrimination. Do you know how many of those were actually proved that they were discriminated against?
I do not have the numbers on the all of the cases between 2010 and 2015. As per the research that I've done with the NCSL, the National Advocates for Pregnant Women, the National Women's Law Center, they track those cases to find out what the different decisions are. And I pulled out the number of cases that I could find that were specific to Georgia or Georgia employers. And as you see in both of those cases, there was need for that person to file that discrimination claim because they ended up almost winning the case.
Thank you.
All right, don't see any more questions. We've got a couple of speakers signed up. Yvonne Robinson. You're going to you want podium? It's, mic should be on. If you'll introduce yourself and who you represent.
This is good. Thank you for allowing me to speak a little bit on this. I'm Yvonne Robinson with the Georgia AFL-CIO, and we represent 130,000 members in the state of Georgia, working people, but we also stand up for people who are workers who are non-union. And in many cases, we have CBAs, collective bargaining agreements, that cover some of this. But for folks that don't have CBAs, it's harder to get employers to understand that, you know, we are valuable, our workers are valuable, and this bill isn't to make a hardship on employers. It is to create a worker-friendly environment. And as Representative Cannon said, Georgia prides themselves on being a great place to do business. But it's scary when we don't value pregnant employees, pregnant women, pregnant employees, and those are pregnant families. Because when the mother in that house gets pregnant, that whole family is pregnant. Most of the time, those are women who are breadwinners in that household. And if they're without work, then that creates a hardship on the family and the community and the state, because then they reach out and they have to get services from the state. And so we think that it's important. Representative Pat Cannon ran down the whole list of all the details, and I don't want to go back through that, but I do want to say that just reasonably accommodating a mother who may not, instead of lifting 50 pounds, lift 20 pounds, will increase that household's income. I've been pregnant before, twice, so I understand. And each pregnancy is not the same. I worked through both of my pregnancies doing strenuous jobs, but I do know that after the first one, I had to take off a little bit of the time, and it was a strain on our family. It's when I could have been doing something more productive. I could have been doing a lighter duty. I could have went on nights where I didn't have to lift. And so just asking these companies to reasonably accommodate is not to create a hardship on business. That is not our point. That is not what we want to do. We want to keep Georgia working. We want to keep families working. We want to keep families providing for the children in those families, feeding those children, not relying on public assistance to feed those children, because that's not what we want to do. We want to work. And I applaud Representative Cannon for speaking out, and I'm just sad that she took all my talking points. And I'll say this, a lot of women will continue to work in a job that is harmful for her and the baby, and that can also create a strain. We see babies born with disabilities all the time. My past life, I worked with special needs kids, and a lot of times it's because parents just couldn't take care of themselves during those pregnancies. And to just change from 50 to 20 pounds could have probably, in some of those cases, prevented some of those illnesses or prevented some of those disabilities and not have been a strain on those families anymore. So I thank you for your time. I'm not going to take a whole lot. I thank Representative Cannon for bringing this issue to the front, and if you have any questions for me, I am here.
Well, you don't seem to have any questions, so thank you very much.
Okay, thank you.
We have Helen Robinson. You'll introduce yourself and who you're with.
Thank you very much. I'm Helen Robinson, Director of Advocacy at the YWCA of Greater Atlanta. We are a nonprofit organization that advocates for the economic empowerment of women in our state. And I just want to reiterate that supporting women in the workforce is a critical strategy to strengthening Georgia's economy and increasing the economic security of families. Unfortunately, as you've heard, all too often, pregnant workers are placed on unpaid leave or can even be terminated when they seek a modest work modification, such as temporary relief from heavy lifting or a stool to sit on or water breaks. And this occurs even when other employees with other types of doctor-prescribed restrictions are allowed to be temporarily reassigned or are provided accommodations. But the employer would not do the same for pregnant workers. So other than this just being a fairness and equity issue, failure to accommodate women workers during pregnancy can result in devastating economic and health consequences for those women and for their families. The woman and her family loses out on much needed income, and she can also lose benefits such as health insurance or even seniority in her position. And of course, many women who cannot afford to take unpaid leave, if that is all they are offered, will continue working without the needed accommodations, and they can find themselves at increased risk of preterm delivery and low birth weight. And unfortunately, our state ranks 47th out of the 50 states for infant mortality. So HB 184 aims to ensure that pregnant women are not pushed out of their jobs when they need a modest, reasonable change at work, while providing clarity to employers, who I'm sure would appreciate that, and while improving public health. And nearly half of states provide these protections. And so we can join these other states and benefit working women, their families, employers, and the economy. And I want to thank you very much for hearing this important issue today.
All right, thank you. You don't seem to have any questions for you either. So, Representative Cannon, we got a couple of things. One, the last speaker brought up accommodations that other employees get for different reasons. Matter of fact, if I read the way I read the SCOTUS decision on Young, that was one of the big keys that UPS allowed other lifting restrictions to be recognized for other medical ailments, but not for this pregnancy one. And is that true, or have you read through the whole decision?
I have read through it twice, so I
And
would agree with you in that.
Which I don't understand why a company would do that. If you make accommodations for a medical condition, it's a medical condition. So, which, whether it's pregnancy or not, didn't seem to make sense. Now, you and I don't quite see eye to eye on how ADA and reasonable accommodations go, but is this more of an enforcement issue than it is anything? If with ADA and the PDA and even the Civil Rights Act of '64 and all of its amendments, it looks like we should have enough laws to cover this. It's a question of whether we're getting it enforced.
I think that the lack of uniformity, given the fact that we have so many employers in Georgia, is one of our first issues. So different employers can do different things, and I'm not trying to make a blanket one-size-fits-all, this type of employer has to do this type of thing. I'm saying that since there's such little uniformity across the employer spectrum, let's at least have each of those employers have those conversations to decide those reasonable accommodations. I do not want it to feel burdensome to employers, but I do think that there's not uniformity. I think the second issue is, like I said, this whole conundrum from the federal opportunities for providing remedy to the employee. So that employee, they're gonna go their whole pregnancy before there's going to be remedy. And they're gonna miss out on all of that employment, all of those health benefits, et cetera. So those two issues, I think, are the reasons why, something like this measure is so important. But the third is because I think there are a number of pieces in this legislation that could be implemented in their own rights. I wanted to bring something that was very comprehensive, that talked about all of the places in which pregnancy discrimination with a lack of reasonable accommodations occur. But for me, it feels very important that we at least have some sort of placard or something in the workplace that says, if you're a pregnant worker, this is what you are able to kind of apply for or ask for.
In the PDA required to be posted in the workplace? PDA notice?
I don't know.
Okay.
I've never seen one in my workplaces. I've worked around a little bit. I don't know. Have y'all seen PDAs?
Yeah.
I don't believe that DOL has it.
They don't have as good as HR managers.
Uh-huh.
I'm in charge of HR at my restaurant, and we don't have
All right. Well, we don't have any more questions, so we thank you for your time.
May I
Thank you for
just
presenting the
close?
bill.
May I
And,
close with one
yes, you may.
small other instrument? I don't know if there's anyone else who's interested in speaking to the measure, and if not, I'd like to thank my co-sponsors for helping me on this issue. A few of them are here. I don't know if y'all have anything to add.
Mine is, hi, Representative Kim Schofield. Just a quick story, just very quick. I was in a department store, and there was a young woman that was pregnant, and she was about 7 months pregnant, and she, looked a little comfortable shifting back and forth, and she called her manager over and said, I need to run to the bathroom. And the manager said, didn't you just take a break an hour ago? She said, yeah, but I have to go again. And she kind of just got frustrated and just started continuing to ring me up. And I said, it's going to be okay. And she says, they don't understand. It's not something I can control that I have to go to the bathroom. And I thought, wow, if we're such a great state to live, work, how can we, a basic human right, deny someone that's pregnant? I'm shopping here, and I wanted to take my business and go elsewhere, but I started talking to her about some of the options, but this woman started to cry because she said that she could not. The manager told her if she continues to have to take more than 1 or 2 bathroom breaks, then she would have to take unpaid leave. She said, I'm a single mom. I need this job. I said, so what are you going to do? She said, I got to wait an hour before I can go to the bathroom.
Thank you. Yes.
And I just want to say, Chairman, that I presented this bill last year, and me and Representative Park County, she was my co-sponsor, and I'm actually co-sponsoring the bill still this year. I think this is just a bill that it's time for Georgia, state of Georgia, as Representative Kim Schofield just stated. It's just time for this bill to get some real traction. I think it's a great bipartisan effort, and it's already a U.S. Supreme Court case that outlines that the federal government should be doing this, and so we should be doing it on the state level here in Georgia. Thank you so much.
Thank you. So I'm just closing with,
Hold on, Representative Cannon, because we had a hand wave of another speaker
Okay.
back
Sorry,
here.
just
So
real quick.
could you introduce yourself?
Yes, sir. I'm Anna Adams with the Georgia Hospital Association. As one of the largest employers in the state, we are supportive of this bill, but I do want to bring one point up. Representative Cannon has talked about Georgia being the #1 state to do business, but one of the things that we are not fantastic at in Georgia is that we are number 49 with regards to maternal mortality. And a lot of that has to do with our women's ability to access prenatal care and to get the prenatal care that they deserve. So having a safe work environment and having the ability to attend your prenatal appointments and make sure that you're following up with your physicians is one of the ways that we can help improve those statistics. Additionally, one of the portions of the bill talks about supplying women with a place where they can express breast milk and feed their babies milk that they've expressed when they go home, which again is statistically proven to lead to healthier children. So these are just some of the statistics from a public health standpoint that as a hospital we are concerned about seeing in our communities. So I just wanted to bring that up. But thank you.
All right, thank you very much. All right, Representative Cannon, you can close it out with the final word.
thank you, closing it out. So House Bill 184 has a lot going on in it. There are a number of provisions included, and I want to continue to work with you each on the issue. So I thank you for listening today. I am, of course, a millennial, so I pay attention to the internet a lot. The other day, I was on the internet looking at hashtags, and one of the hashtags that was trending in Georgia was hashtag we work, they work. And I looked at the hashtag because one of my other representatives, Representative Erica Thomas, told me she was at the Boys and Girls Club's annual time to come to the Capitol. They were here and they had to present to their colleagues, young colleagues, what type of bills they thought were interesting. And I've never spoken with these people before and still haven't, but they chose my bill. And they created this new hashtag, we work, they work. And it talks about why they think that pregnant workers should be given reasonable accommodations. So I say that to say, even if, there have been other times that we have not been able to provide reasonable accommodations to workers in the past, our future employees are looking and they're watching, and I hope that we can make them proud by doing some work with House Bill 184. So thank you.
All right, thank you very much. And with that, we are adjourned.